Placement Assistant Cell extends the most warm welcome to the August gathering. It is indeed a matter of immense pleasure for me to stand here on behalf of the cell and welcome our guest of honor, Mr. Swadat Ahmed Kirmani, our Honorable Vice Chancellor, Professor Dr. Chanchal Kumar Singh, Honorable Registrar, Dr. Professor S.S. Jaiswal, our Chairperson, Dr. Praveen Kumar, esteemed faculty members and fellow students, to the event we are all gathered here to witness. I sincerely invite our Honorable Vice Chancellor, our Chairperson, and Dr. Chandrika to felicitate our guest of honor. I request everybody to stand for the Kulgeet, please.
योगकरं सुकौशलम् योगकरं सुकौशलम् हिमाचल प्रदेश राष्ट्र विधि विश्व गुरु बनना है क्यों न गुरूर करें हिमालय से ऊंचा मस्तक जिसका दूरदर्शिता आसमान की परतें चिरे हवाएं झूम झूम नाम ले जिसका बर्फ कोमलता में दृढ़ता भरे देवित्य विधि के हर विधान की मस्तक झुके कर वेदी है संविधान की प्यार करे शक्ति शासन के प्राण की और अपने भारत देश महान की तथ्य से अवगत करा तत्व अंगीकृत कराए तर्क को अंगीभूत करा वितर्क की पूर्ण आहुति डलवाए कहता है हर युवा यहाँ लेखनी और वाणी वीर बने कानूनी मदद का दरिया बहा वाद विवाद प्रतिद्वंदी बने के आंचल से चुरा सफेदी चलाओ न्यायालय संस्कारों से मिटाए अन्याय श्वेत श्याम वर्दी ख्याति बढ़े देव भूमि की जिससे गुरु बनना है क्यों ना गुरूर करें.
I extend our deepest and most heartfelt gratitude to Mr. Kirmani for undertaking an arduous journey to grace us with his presence today. I'm delighted to announce that we shall have the distinct honor of hearing Mr. Kirmani enlighten us with his insights on the fascinating topics of careers in dispute resolution and his journey from being a student of law to a partner at a law firm. The world of dispute resolution is extensive and complex. I am sure everyone here would be keen on seeing the roadmap that would be traced for us today when Sir shares his anecdotes and lessons from his established and remarkable practice of 12 years. Therefore, without further ado, I would like to invite Honorable Vice Chancellor Sir to formally welcome our guest of honor.
Good morning, everyone. Good morning, sir. Swagat Ahmed, Kirmani. I had a small discussion in the office to join you here with Kirmani, and I must say that you are going to interact with a person who is self-made. He has left many opportunities which he thought that it's not my creation or my product of my toil. So you are going to interact with a person who has been a Ford Scholar, sir, fellowship. He has left opportunities to work in and in good opportunities in London and settled. He has abandoned all the opportunities created by his legacy family and made himself on his own, right from Kashmir to Jammu to Bangalore. Now, for us, this is the first event perhaps by PAC, where the importance of, and in a way, we are initiating the interface between the firms, industry, and the academics. Ultimately, there are two things which counts for a law school. One is research, and the second is uh, the outcome where you are placed or the students are placed. They join industry or bar or firms. Both of these things are complementary. A law school cannot make a name either by going one alone, either only research or only placement. So this is first interaction, our first interface that we are going to have. You will have at least in each semester several of these interactions from tier one firms, advocates and industry. So I congratulate Dr. Parvinji. I must congratulate to pursue this matter with university and Yukti Akshita for putting the, and hard work to arrange. Uh, in this semester, we are having this first event, perhaps. Next semester, we are going to have more such events and visits with similar people. So I welcome, sir, welcome you to be the first person to complete the circuit. So, sir has been a student like me, everyone, and we have to come back to students through industry, through corporate. So that is the circle for the has to be completed, and that feeling I found in you, sir. I read in you. That's great, sir. Welcome you, sir. Thank you.
Thank you, sir. It is perhaps the first event that we are having, and this is not the end but the beginning. And we are glad to have Mr. Kirmani with us to initiate the sessions and the lectures and events from the placement assistant cell. I would like to invite Dr. Chandrika, convener internship committee, to formally introduce our guest of honor to everyone here.
A very good morning to all of you. And it is with a great pleasure that I welcome each and every one of you to the special event thoughtfully organized by our dedicated placement assistance cell. Today, we are deeply honored to host an illustrious figure in the realm of law, a distinguished lawyer whose career is marked by numerous achievements and contributions to the legal field, Mr. Swadat Ahmed Kirmani. We welcome you, sir. With 12 years of robust experience as a lawyer, Sir has established himself as a trusted advisor to both domestic and international clients, navigating a wide array of multifaceted disputes. Presently a partner at Indus Law Bangalore, his area of expertise are impressively diverse, encompassing litigation, mergers and amalgamations, projects, claims and disputes, with a notable focus on infrastructure disputes, as well as insolvency and white-collar crimes. His illustrious career includes handling arbitrations under the esteemed rules of various international and national arbitration bodies. His legal prowess is not confined to arbitrations alone. He regularly advises and represents clients before various courts, extending his expertise up to the Supreme Court of India. In the realm of infrastructure and energy disputes, his involvement is extensive, as Sir has tackled various technical disputes related to metro rail projects, strategic oil reserves, solar project installations, roads and highways, and pioneering test tracks for high-speed vehicle testing in India. His exceptional contributions to the legal field have not gone unnoticed. In the year 2024, he was recognized by Legal 500 as a recommended lawyer for arbitration and litigation for the Asia-Pacific region, a testament to his outstanding professional achievements and expertise. In addition to his legal practice, he is actively involved in the legal community. He serves as a member of the Young IAMC Steering Committee for the term 2024 and 2022-2024, contributes regularly to leading law magazines, and is a sought-after speaker at various conferences and seminars. His commitment to education is evident in his lectures at numerous law colleges, where he shares his knowledge and insights on dispute resolution mechanisms. Dear students, this event offers more than just the chance to hear from an expert. It provides you all with a unique opportunity to interact and engage with someone who has masterfully navigated the complexities of a legal career. As Justice Oliver Holmes once said, the life of the law has not been logic, it has been experience. Our guest journey exemplifies the power of hard work, perseverance, and unwavering commitment to justice. This is a rare chance to gain wisdom from someone who has truly lived these experiences. I encourage each one of you to actively engage, ask questions, and fully seize the opportunity. As Socrates famously said, education is the kindling of a flame, not filling of a vessel. Let the interaction ignite your passion for learning and professional growth. So please join me in giving warm welcome to Sir. Sir, please. Thank you.
Without further ado, for all that we've been waiting, I invite Mr. Swadat Ahmed Kirmani to grace us with his presence and highlight the testing waters of dispute resolution.
Hi, good morning. I thought a little more energy, a little more. Yeah, sounds about right. First of all, thank you so much for having me here. And thank you so much for, turning out. All of you are looking fantastic. Great to see you. And whatever your teachers and your professors have said about me, um, I hope my wife and my mother were here to listen to that. Because you're never a prophet in your own land. They probably would take me more seriously. But please don't keep any of that in mind. Forget all of that. I'm just a student of law, just a little older to you, just a little bit more gray hair. That's my introduction. That's who I am. I'm a student of law. We're all on this journey of learning about law, on learning about subjects that interest us, that we like, that we find easy. So we're all students here, and I'm not here to give you any lectures. Your teachers are doing a great job at that. So I'm here just to sort of have a chat with all of you all, and maybe by the end of the day be able to answer some questions that you guys may have, some thoughts about how to go about law, life, and things, how things actually happen. So that's about it. It's more like an interaction. It's not a lecture. Please feel free to raise your hand whenever you guys want to. I'm more than happy to take any questions, answer any questions. So I think you guys know how we are placed for the day. We're gonna do a quick session on disputes, the career options in disputes. That's gonna be our first session, and then we're gonna break for lunch, and then we're gonna do the second session, which I am dreading because when Akshita was telling me that I need to come and speak about my journey, it sort of did really scare me. But she was relentless. She was like, "No, you have to." So we'll try to cover that, and I hope your teachers don't hate me after that. Okay, so everybody can hear me. Okay, we have spare mics in case somebody wants those. Um, So I don't like to be on the stage and all. It just feels very this thing. So I usually, and I'm not so old also that I can't stand for an hour or so. So despite what you guys might think, okay. Okay, zoom out a bit. Zoom out. I don't want to lose out any of this. Can you just listen? Okay, this is full screen. Okay, sure. Sounds about that. Okay, setting the stage: careers in dispute resolution after law school. So, how many of you know what you guys want to do after law school? Okay, 1, 2, 3, 4, 5, 6, 7, 8, 9. Okay, I'm happy at least one guy has raised his hand. He's taking one for the team. Okay, great. So, what do you want to do after law school? To pursue litigation. Fantastic. What do you want to do? The guy who raised his hand there.
Sir, I want to be an Indian Foreign Service officer.
Fantastic. So, he wants to do UPSC. Great. So, some of you know what you want to do. Some of you are still figuring out. Nothing wrong with either of those because the kind of profession that we are in, it takes some time to sort of figure out what you do because pure diversity of the options that we have, which is a fantastic thing when it comes to law because you could be anything. After you study law, you can do so many things. It's so many opportunities open up, despite what people might say. But so many opportunities will open up for you guys after you've studied law. Good thing is, like I always say, this is like the best time to study law. 20 years ago, 30 years ago, only people who probably didn't get anything else would end up in law, right? But now, law is the first preference of many students, which is a great thing because this is the time to study law. Okay, this is the this is the time when you have so many opportunities that come up that you guys can explore, that you guys can get into. You know, right from litigation to corporate, to technology, to in-house, to judiciary, everything is there. I mean, you know, basically the sky is your canvas. So, how many of you want to get into disputes? Okay, that's very. And how many of you want to do corporate? Okay, and judiciary? Okay, great. So we'll sort of like, you know, try to go through some of the options that we have, especially in disputes. Of course, I'll be talking about other things as well, not just confined to disputes. You can obviously ask me questions about other practice areas as well, and I'm happy to take those as well. So what are we going to cover? On. On. Yeah. So first of all, what we're going to see is what's a dispute and what's a conflict, because many times we use these terms interchangeably. They do not mean the same thing. They're a huge set and a subset. We just try to figure out what's a dispute, what's a conflict. Then we'll see what is dispute resolution, what are the mechanisms for alternative dispute resolutions, then some essential differences between those mechanisms, what is ODR, and finally, what are the career opportunities. So can someone tell me the difference? Okay, what is a dispute? Can someone tell me what's a dispute? Anyone, especially those ones who want to do dispute resolution. What is a dispute? Yeah. Take a shot. Come on, just take a shot.
Dispute could vary in person, situation to situation. The legal sense it would mean when a legal question essentially arises. That is when a dispute begins. Now,
Okay.
it would differ depending on the situation what the parties want for themselves.
So a disagreement, right? Essentially a disagreement. Okay. Anyone else? What's a dispute? I'm sure you'll have disputes with your friends, your family, you know, every day. What's a dispute? Yeah. Okay. Sure. Okay, what's a conflict?
Essentially, it would be like a coalition of interests of two parties. It does not necessarily have to be based on a previous contract. Like you can have a conflict without having a contract.
Right? But you can have a dispute without having a contract too, right? Right. I mean, you're close, but what's the essential difference? Anyone? No one is marking you. There are no wrong answers. Don't worry. Ma'am, please don't mark them. Yeah.
Does not have to necessarily materialize to be conflicts.
Okay.
Maybe conflicts lead to
That's an interesting answer. That's an interesting answer. Nice, very good. Okay, so let's see. So what's a dispute? Everybody can see this, right? I think you have screens there also. So it's a short-term disagreement that can be resolved. Okay? It can be contractual, it can be non-contractual, it can be commercial, non-commercial. It's a short-term disagreement between two parties that can be resolved. You know, you're saying that this chair belongs to you, she's saying this chair belongs to you, it can be resolved. Whereas a conflict is a serious disagreement or argument, typically one that's long drawn. Okay. It can be, to give you an example, like, you know, what's happening in, like, let's say, you know, the Israel and Palestine, that's a conflict, right? So right now there's a war, that's a dispute, that's emanating out of a conflict. Without taking sides, but that's emanating out of a conflict, right? Because there's a conflict, there's a deeper issue that is happening there. That's a conflict. Now, dispute can be resolved by considering and evaluating interest. So, some of the words you will see are highlighted. They're highlighted for a reason, they're not just bad drafting. So, you evaluate the interests of the parties, you determine their rights to a reasonable solution. So, when you talk about determining the rights, what are we referring to?
the legal rights.
The legal rights, okay, correct. Anyone else? So you go to a court, you make a claim for certain rights, you show some law that supports you. Conversely, the other party will come, they will try to disprove your rights. Then they will have some law to back them up, and then the court will decide what is a reasonable solution. Basis the law. Conflict is generally very non-negotiable because it's a deeper issue that arises. Okay, let's say there are two brothers in a family. Okay, and one of them feels that the parents have always been taking the other brother's side. Okay, so there arises, this deep sense of hatred, for his family. Okay, there is a, there's a dislike. Now he's at conflict with his family. Then, when the parents are dividing the property, they may say, okay, land A goes to brother A, land B goes to brother B. But then here B may say, no, this land should go to both of us, for example. Right? So there's a dispute on that land, but the dispute is emanating from a conflict. Correct? Conflict is a much deeper issue. Dispute is just a smaller subset of the conflict. There's a conflict that is there. A disagreement on the point of law or fact, or even certain legal rights, obligations, interests between two or more parties. What we just discussed, right? The disagreement on a question of law. Let's say, any certain point of let's say I owe your professor some money. Now he makes a claim for it after 3 years when the limitation is over. He goes to the court and says that, Swadat owes me X amount of money. I go and say that even if I owe, he hasn't done anything for last 3 years. Now he is barred by limitation, right? There's a dispute between him and me, but the law will see, okay, that whether he's entitled to it or not, right? But the conflict could be something else. Conflict could be that he gave me the money because he thought I needed it. He never intended to take it back. But now there are certain acrimonious things that happen between him and me, and now he hates me. So he wants that money back. Right? It's more of an emotional thing, sometimes more of an ego thing. That's where the conflict comes from. That's why when we talk about dispute resolution, we talk about conflict avoidance. Okay. So if you try to avoid a conflict, if you are able to avoid a conflict, you are able to avoid a dispute. Okay, everybody with me till now? Okay. So possibility of resolving is remote or difficult, right? Because you'll have to obviously cut through many issues, go to a deeper, realm and understand what happens. So in dispute, a disagreement is specific. Okay, it's specific that I owe him money. He wants to take money from me. It's a very specific issue, correct? But conflict could be that he feels that I don't respect him. And over a period of time, he feels, that day he disrespected me, that day he said something to me, that day he made fun of me, in front of my friends. So then he has that a broad variety of issues. Now, some of them may be even intangible. Unlike, thinking, no, I'm elder, I should sit in the front. Just give me an example, okay? Don't do that. One party is seeking to enforce the rights or claims. He's trying to enforce his right to recover money. That's an example. Okay. Just a disclaimer, I don't owe him any money. Okay. I don't want you guys to be thinking that, he owes our professor a lot of money. And that's not the case. So, but in conflict, issues that are considered deeply and extremely serious due to difference of opinion, right? A difference of opinion may not be a legal issue at all. It not be something that you need to go to the court for. Morals or values, again, very subjective thing, right? What may be morally right for me may not be morally right for you. Okay? Value system. We are all raised up in different environments. We all have different value systems. Even two siblings raised in the same home, we have a separate set of value system. Not necessarily, same. So that's why you see conflicts in between brothers who were raised by the same family. issues pertaining to security, authority, power, more of which, if it's not resolved, it can lead to physical violence. He may come at me, or if in a larger context there's a war that happens, correct? So that's the essential difference between dispute and conflict. Because when you are into dispute resolution or any other practice area as well, or even if you go into judiciary, so as a judge also you have to be very disassociated with the case and see, is there a dispute or it's merely a conflict? And if it's a conflict, then your approach has to be different. I will give an example of a conflict when we talk about mediation, because this is one case I did, and it was beautiful. It was one of those highlights of my career, and it happened like quite a few years ago. So we'll talk about that, and if I forget, please remind me to talk about that case. So what are the common modes of dispute resolution? It's litigation. Everybody knows what is litigation. You go to the court, you do tariq pe tariq. Okay. By the way, it does not happen. Those of you who don't know, it does not happen. You raise your voice in front of the judge. Next thing you know, you're out of the court. And if you're lucky, you're just out of the court, or you're inside the lockup. Okay? I know it talks like the process, the procedure is entirely different from what we see in the movies. So I remember I was in one of the cases that we were working, and there was this one intern. They were working with me. I'm using they not because I'm woke. I'm using they because I don't want to reveal the gender. So they were working with me, and they come to me and they said, "Sir," I said, "What?" So can we subpoena them? I said, "What? Can we subpoena them?" I said, "Sorry, what do you mean?" He said, "We should subpoena them and then we should ask them these questions." I said, "But under what law?" So they say that, "I don't know the law, but I've seen Hari Specter doing it many times." So, okay. US, India, no subpoena. Okay? And B is silent, so it's subpoena. Okay? So these things happen. It's absolutely normal to happen. It's okay to make those mistakes. They're still much better. I would still say they're much better than Tariq pe Tariq that our own Sunny Deol did. Nothing like that sort of happens in the court. We are extremely, extremely courteous to the court. Even if we feel the judge is being absolutely, absolutely wrong about something, you're still not supposed to raise your voice. You're still supposed to be extremely, extremely obedient, extremely respectful, because it's not the person, it's the chair that you are respecting, and which is something you must always bear in mind. Especially those who go for mooting. Just one tip I would tell you is that when you guys are mooting, don't think of it just as mooting. Think of it as you're in actual court. How many of you guys moot? Oh, that's almost. You must be proud of them.
Yes. Yeah.
So when you moot, again, very, very minor things, but that sort of sets you apart. For example, when you are asking the judge to open a certain page, okay. So what usually happens is that the students will say, "Please refer to page number 48," and they'll start reading. So you don't do that. Neither in moots nor in courts. You stop, you wait for the judge to open that page. And then you don't say that, "Do you have that page?" No. When I argue, I say that, "Am I with the court? Or am I there with my lords?" Because my lords are supposed to be there. I am supposed to be with the judge. The judge isn't supposed to be with me. Okay? So we always say, "Am I there with my lords?" I am already there. I am the one who's opened the page. I am the one who's telling him what to read. But I have to be courteous. I have to be respectful. So I'll say, "Am I there with my lords?" Okay? Secondly, whenever you start, you always say, "May it please your honor. May it please my lords." So these are certain things that help you a long way. Just this Monday, I was going to the office, and this is an actual scenario that happened. Okay, I was going to the office. I get a call from one of my colleagues, and one of my other colleagues was supposed to go and attend a matter. Okay. Something came up, some personal issue. He called me up and he said that, can you go and attend this matter? Because it's the first hearing and we need a stay. You guys know what a stay is? Like interim injunction. We need a stay, it's an appeal. So I said, sure, no problem. So I'll go to the office, I'll read up the file. How much time do I have? He said, firstly, file is not in the office, it's not in the court, and you have about like 15-20 minutes, which is not the time you require to prepare, okay? So then I had my other colleague who was briefing me on this matter. So we were going to the court. I told him on the way to brief me on the matter. You know the briefing, right? We brief the senior who has to appear and argue. So he gave me the file. He asked me to read through it, and I realized we did not have a case. So I realized that the judges just basically, and my best case was that she'll just laugh at me. Worst case was she'll like humiliate me. So with that in mind, I said, okay, let's take a chance because as lawyers you get very thick skinned, which you guys must be if you want to survive in law. So I go, but what do? I didn't start arguing. I didn't open the file, but I read the court. And when I reached the court, there was no one except the judges. So one thing was okay, that even if I'm humiliated, there is nobody else. It's just my team. But more importantly, all other matters were over. So it was just my matter, which they were supposed to hear. So when I go, what was the first thing? What do you think was the first thing I would have said to the court? Can anybody venture a guess? What's the first thing you guys think I have said to the court? Take a wild guess. Anything? Come on, tell me. Take a wild guess. Anybody? First thing I would have gone and said to the court, to the judges basically. When you say court, you mean the judges. Anybody? Lighten up the mood. How? Crack some jokes. Stand up. No. So the first thing I said is that, of course, after I say, "May please, Your Honor," first thing I said that I express regret and I deeply apologize for not being there when the matter was first called out and it had to be passed over. And I realized that all of the matters were over, and Your Honors were sitting. There were two judges. Your Honors were sitting only to hear me. So my unconditional apologies for that. So what happened with that was that I lightened up the mood, or rather, I got them into my corner. So I started on a note where they liked me. Okay. And you will need all these things to do when you are in the litigation, because sometimes you have to get an adjournment, it's a big, big task. And then when I was arguing, so she asked me a couple of questions which I didn't want to answer because then it would have exposed my client. So what I did was I deflected, saying that it's a very interesting question, but can I just come to that? I'll answer that along with my another point. Okay. Don't pull that off in the moods because unless you actually have an answer for that. And then she forgot it. We got to stay, everybody happy, we go home. But what I'm going to tell you is that courtesy and humility will take you places, especially if you are in this profession. Okay. No matter what people tell you, my 12 years of experience, being rude and arrogant never helps. It never ever helps. Sometimes in cases we position, what we call as positioning. Okay, we try to take a very hard stance just to show the other person that we are a very tough nut to crack or a very hard bargain. Those are strategic questions. Those are calls that you probably shouldn't be taking right now. Those are calls we take after like a lot of experience, lot of discussions and everything. And that's where we do those things. Okay? But it always pays to be courteous. So that's what litigation is. Essentially, you go to the court, you have lawyers on each side, you have a case, civil case, criminal case, service matters, any sort of court that you visit. It's called litigation. Then we have arbitration. So all of you all know what is arbitration? Great. What is arbitration? I don't know. Yeah. Yeah, tell me.
Arbitration is basically an out-of-court settlement mechanism
Okay.
where parties, instead of approaching the court itself, go to a tribunal to get their, or if not in case tribunal, they have an arbitrator who solves their dispute for them. Now, the question that might arise is it similar to how courts judgments are enforceable?
Yeah.
Then the arbitral award has become enforceable as per the Arbitration Act of India, and other jurisdictions have this.
Okay, perfect. Okay. So that's basically what arbitration is. It's an alternative dispute resolution mechanism which is governed by the Arbitration and Conciliation Act. And the procedure is laid down in that act. It is a dispute resolution mechanism where we try to avoid going to the courts. We end up going to the courts in one way or the other. So then comes mediation. Who can tell me what's mediation? Yes, sir. Both of you. Okay, you go first, then you tell me.
Mediation is the when you voluntarily ask the parties to come and settle down the dispute by their own terms and conditions.
Okay, yes.
If we talk about mediation or conciliation, more or less they are both distinct things, but mediation is just a leader, but conciliation can take advisory more than the same procedure.
Okay. So mediation is again an alternative dispute resolution mechanism where you have a mediator who facilitates the resolution of the disputes. Please pay attention to the word facilitates because he has to facilitate. He will not give a decision. He will not tell you what is right, what is wrong. He'll only be there as a facilitation agent. Then you have conciliation, like your friend said, it's similar to mediation, but here the conciliator takes more of an active role, more of an advisory role, more of an active role where he'll say, okay, fine, I think we can do this. But again, in this, in this, the parties will decide what to do. So party autonomy is something that is the bedrock of arbitration, mediation, and conciliation. Varying degrees of party autonomy is there. But party autonomy is something that is the benchmark, that is the bedrock on which these things are. So let's just dig a little deeper on what kind of litigation is there. You guys want to read this for a minute? Please do. The reason I've put all this is there because sometimes we look at only a couple of options and we tend to miss other things, which again is a great practice area to be in, fantastic practice area to make money in. So like I said, it's a traditional way of resolving any disputes before a court of law, and it's adversarial in nature. So what does it mean? What does adversarial in nature mean? Yes.
Adversarial means that the judgment is binding upon you, and even if it's against you, it has to be from you.
Okay. Anyone else wants to take a shot? Yes.
Am I audible to you?
Yeah.
Yeah. So earlier, India used to follow interstitial judiciary, but currently it's adversarial, which means that the judge is not allowed to inquire in a particular case. He or she can only adjudicate on a particular dispute, but inquiry is not allowed.
Okay. Yes. You wanted to say something? Same thing.
Part in arguing the cases.
Okay, all of them are right answers. One thing is that adversarial indicates that one party wins and other party loses. Okay, it's that. So broadly, when you go to the court, what are certain laws? CPC, if it's a civil case. Criminal, of course, CRPC, which has now been replaced by Bharatiya Nagarik Suraksha Samhita Act, which is now Act, but we're still sort of like in the process of understanding and figuring out how that's going to work and everything. That's a debate for some other day. So types of litigation broadly civil and criminal, right? So what is civil? Your NCLT, NCLAT, IPR, consumer, debt recovery, property, family, broad aspects of it. Criminal, you have white collar, quasi criminal, other criminal. Can someone tell me what's a quasi criminal case?
These cases have both the elements of the civil and the criminal case. The best example would be cases related to financial defaults, which can entail a criminal liability as well on participators and also a civil liability.
Like a check bounce.
Exactly.
Check bounce. Yeah, okay, good. So that's primarily this litigation means. So obviously there could be a case which is a family law matter. It could have criminal elements as well. For example, divorce would be a civil case, but domestic violence can either be civil or criminal. Okay? Maintenance, 125 CRPC, right? So again, civil, criminal elements can be there. Now, IPR infringement can be civil because, if somebody has infringed your IPR, you go to the court, you ask for some damages. But there could be a criminal angle as well. But basically, broadly, when we talk about types of litigation, we usually talk about civil and criminal, and service matters. They will fall in civil, right? So far, so good. Everybody with me? What is ADR? I think I've already answered that, but still. Yeah.
ADR is alternative dispute resolution. You all know the litigation is very time-taking process, and time is money for the present time. So ADR is the process where we split the time and it is really useful for the financial problem.
Sure. Yeah. Yes, alternative dispute resolution mechanism. What about this one? The third one that I put there.
Identifying what is right for your case. In some cases, arbitration might be the most suitable method, but in other cases, I would rather negotiate and save all the money that I'm spending in those disputes.
Right. That's right. So we call it alternative because it's an alternative to the litigation, but now it has become the first choice of dispute resolution. That's why we also call it appropriate. I mean, but it's not a legal term, it's just what I like to call it. Any mechanism followed outside the court of law, traditional method, like we discussed, right, would be an alternative dispute resolution mechanism. Arbitration, mediation, and conciliation are the most common ones. Can someone tell me, about mediation and conciliation? Let's leave arbitration or even arbitration. Any idea when this would have started? Yeah. How did he mediate?
He went to Hastinapur for the mediation. He gave offers, he got instrumented and agreed. So we can trace it back to Machibachi also.
Correct. That's right. Yes, you raised your hand. Same thing. Okay. How many of you know King Solomon? Yeah. So it said that King Solomon was the first guy to use ADR. When two women went to him and said that this boy is my son and this boy is my son. That's where he used his brains and he sort of decided. Okay, let's come to more recent. I understand Mahabharata and King Solomon, but no, it's like a really long time ago. So let's see something closer, which probably some of you would have heard, at least your parents talking about. So let's talk about last 100, 150 years. What do you guys think? Yeah.
The first arbitration case was, like, if I am not wrong, if I'm not wrong with my facts, the first arbitration case started only in the early 20th century, where there was an arbitration between, I think, USA and one other country over a dispute over some oil fields or some mines.
Okay, correct.
And after
Come closer home.
now,
Yeah, no, I'm saying come closer to home. India. Let's talk about our country. Somebody raised the hand there. Yeah, tell me. Yeah, yeah.
I was talking about the introduction of PCA, and I think much was talking about Iran and US like so I thought PCA was the inception of commercial international.
I'm talking about Indian context. Let's talk about India. There's something there. Yes. Exactly. See, we're talking about US and Iran and everything, but why are you not looking closer to home? Panchayat. What were panchayats? What were those dudes doing? Right? Even today, in some of the remote villages, you have panch and sarpanch. Right? They're basically mediating the disputes, and they are sometimes much better than our traditional dispute resolution forums because people take them seriously, people listen to them. Right? You've had, like, panchayats deciding such big issues, they resolve conflicts. They make sure that even disputes don't even arise because at the conflict level only, they've culled it. Right? And it's something that, like the movies, you've seen some of the movies, talk about panchayats. I remember one movie, Swades. How many of you have seen that? See, you saw the role that panchayat played in that, right? There's a very bad Bollywood movie, but I'm guilty of watching it. It's called Bulandi. How many of you have watched it? He understands what I'm saying. So the reason I spoke about that movie is that in that movie, Rajnikant plays the Sarpanch. Yeah, same one. I would have tried to do that with the shawl, but I don't think I'll be able to pull that off. So what he does is, so there's a case. I'm not going to get into the legalities because, of course, it's a movie, right? In that case, what happens is that Shakti Kapoor is accused of rape. Okay. Then he says that, and Shakti Kapoor happens to be his nephew also. But he says that I don't care, he's my nephew, and still adjudicate. So he says, call for witness. That girl's mother or somebody who's lived a long time ago comes and says that I saw this thing happening. Shakti Kapoor says, no, you're a mother, right? Now, the principle here is that she's an interested party in that case. That's why her evidence was not taken. Okay. But this is all coming from the panchayat system. So you can understand how evolved the panchayat system was. They may not be as suave as our arbitral judges, but they were evolved, right? So then there's another kid. He comes and he says, I saw this happening and whatever. I saw him taking her forcefully and everything and all those things. And then he orders and he says ki inke pure khandan ka bhishkar, which is basically a boycott, right? For 20 years. So nobody's going to have any business with them. Nobody's going to talk to them. Nobody's going to get married into their family. You're going to sell them anything. And they basically, their lives are ruined. And not only him, his entire family. Rajnikant's own sister. She also suffers that boycott. But that actually shows you the power of panchayats, right? Panchayats did yield that kind of power at some point of time, right? So, in our context, and when we talk about ADR, we of course talk about how West has influenced it, and rightly so. But we tend to forget how we have contributed to the ADR as a country. So that's something that you guys should learn and take pride in, right? As to what is happening, how we have sort of contributed to the system. We are not new to the system. We've known the system, we've implemented the system, we've been there. And please, I'm not talking about some other panchayats that are there. I don't support that, okay? Before anybody gets any ideas. So yes, mediation and conciliation and arbitration has been there. even today, if you go in a village, okay, if there's a dispute in two families, they'll get a village elder to come and, resolve the dispute. What's he essentially doing? I mean, he may not know the terms conflict, dispute, evidence, okay, but he uses common sense. And that's where we need to think. See, law is all about common sense. You don't need a book to tell you that don't steal. Of course, you know it. You don't need a book to tell you that don't drink and drive and then write an essay. You don't need that. Right? Am I making sense? You understand what I'm trying to say? It's common sense, it's interpretation, it's understanding the human mind and applying that interpretation, talking about it, discussing it, and using it to resolve a dispute, resolve a conflict. Like I said, arbitration, mediation, and conciliation, most popular in this context. And of course, we've discussed our panchayati system as well. Mediation. So, the biggest problem that mediation faces, rather, I hope faced till now, was what? Anyone tell me what's the problem with mediation, where mediation sort of like, loses the steam? Yes. Exactly. Exactly. 100% right. And that's what my issue has always been with mediation. I am somebody who's very pro mediation. I'm a trained mediator also. And whenever we discuss these things, I say that I'm a disputes lawyer, but who tries to avoid disputes. Because it's not going to help anybody. We need to sort of like move ahead. Problem is with mediation, you can't enforce it. And if I have agreed on something with you, and then I'm again going to the court to enforce it, might as well have just gone in the first place, right? So mediation relies a lot on your niceness and everything. But hopefully that's going to change because we have a new mediation act, which basically means that a mediated settlement will now be enforceable as what? Decree of the court. Now, certain mediated settlements are enforceable as decree of the court. Can anyone tell me what are those? I've actually answered the question, so you just need to pick up the words.
So all those settlements which the parties arrive at in the course of mediation by way of an agreement.
That's right, but how will this become enforceable? Oh, now because of the act. I'm saying if when this act was not there, but there were some agreements that would be enforceable of the court. Anyone? Yes, sir. Right. Yes, that's one bit of it. So other bit of it is that if you've gone to mediation because of a court order, right? Then you go and give back that mediation settlement to the court, and then court says this is a degree. So essentially it becomes a degree, and that brings me to the question that case I wanted to talk about. So now in 2019, we got a case. There was this one gentleman. He was ex-serviceman, ex-army. He had a brother who had expired. He had a son and he had two nephews from the brother who had expired. They lived in one of the good areas of South Delhi, but the house was in a very pathetic condition. Reason was that there was a huge dispute between him and his nephews. So he had second floor. The nephews had first and ground. Sorry, the nephews had first. He had ground and second. So what he would do is he would lock the staircase. So they had to build a staircase from outside. Okay. And then in the evenings, when they would go out, he would decide to water the plants. And sometimes when he was little too tipsy, he would start abusing them. Then they got fed up of this. They filed a case. Easement rights and everything, and partition this. What is happening? He's just making our lives miserable. We have money, but we can't renovate because every time we try to renovate, he sort of gets drunk and starts abusing people, and they run away. It's a huge dispute. And when this gentleman came to our office, again, like, he was like left, right, and center saying that, I'll do this to them and all that things. Well, as lawyers, we are obviously not, supposed to get emotional about those cases. It's okay, fine, we'll see. But something in my head said to me that it's actually a lot simpler than it looks. So when we entered appearance, which was basically we were the defendants, and we entered appearance means that when we go to the court for the first time and say that we are appearing for the defendants and we will file our wakalatnama, and the judge happened to sort of like, I happened to appear before that judge quite a few times. So he sort of like, knew me in that sense, and sort of like, knew that I'll not say something just for the heck of it. So he would give me that respect. So I said to the judge, I said, if I make a suggestion. He said, yes. He said, may I suggest that this matter may be sent to mediation because I feel there's a chance of settlement. Now, for the judges, it's also good because it gives them some points in their annual appraisals and all that they have if it gets resolved. So he was happy to send to the mediation. We went to the mediation, first sitting of the mediation, and the mediator wasn't even trained. He was some retired judge or something like that. He wasn't even trained mediator. But then again, that's how the system works. He was there. So these nephews come and I see them for the first time there. My client is there. And the moment they enter, and he starts abusing them again. So the mediator tells me, Vakil sahab, ye kya hai? I said, sir, to hearing lagega. And then the opposite side's lawyer happened to be a friend of mine. So I requested him, I said, can I speak to your clients for a couple of minutes? Which was an unusual request to me. He said, why? I said, just give me 2 minutes, you can be there. But I do feel that, they can do something about this case. So he said, okay. I mean, reluctantly, he said, okay. So I went to these 2 guys and I obviously, said hi to them. And they were very courteous to me because obviously I was a lawyer. But so I told them, I said, can I just say something to you guys? And it's not going to cost you anything, but it might just save you a lot of time and trouble and money. They were so fed up with the uncle, they said, okay, tell us what it is. I said, next time your uncle comes, no, go and touch his feet. I said, are you crazy? ये आदमी गालियां निकाल रहा है. I said, कुछ नहीं होगा. He's anyway a father, like he's an uncle. I'm not saying to go and touch somebody who's junior to you, touch his feet. You would have touched his feet like a million times before. Just go and touch his feet and just say something nice to him. So the elder brother was a little dicey, but the younger one said, okay, fine, we'll do it. So I said, okay, fine. The next hearing, my client comes, again, he's like, very bad mood and like standing like this, very strong position. So both of them come, they touch his feet, they hug him, and then they say, uncle, how are you doing? Or something like that. This guy hugged them back and started crying. There's something poetic about a 75-year-old guy who's crying like a 2-year-old kid. And then he started howling. He was so emotional about it. He started crying. And he said, I don't care about the house. Ever since your father died, you guys forgot me. And which is what they realized. They said, but we thought you had your own son sort of taking care of you and everything. We didn't think that we are supposed to take care of you, but we realized that we should have at least. He said, I don't want to take care of me. But why don't you guys come and have a cup of tea with me? Why don't you come and sit with me sometimes? And they were like in a shock. Everybody was in a shock. I was happy that my idea worked, but I was also shocked. कि भाई ये तो कुछ ज़्यादा जल्दी हो गया, right? But there is something so beautiful about it. See, that's the power of mediation, the power of human emotions. That's where mediation comes into play. And resultantly, what happens? They agreed. Okay, they said we'll renovate the whole house. We'll take care of the expenses ourselves, and we're sorry. He said, then you break down the stair that you made outside, and you come from the inside stairs. And then, of course, those lawyers were very thankful to me. They said, thank you so much and all. But the reason I said this case about this case is because, that is the power. What was it? It was nothing, just an ego issue. So it wasn't a dispute. Let's go back to our first slide. What was it? It's a conflict. Dispute was that he's not letting them, he's not giving them that easement. They had a right to easement. That was a dispute. But what would the court would have done at best? Said, okay, fine, you allow them, the stairs and everything. But would that resolve? It would not. He would still water his plants in the evening when they went out to make sure that the water goes into their balcony. Right? So that's why it's important. Now, why that mediation settlement became enforceable is because we took that settlement, took back to the court, and the court made that a part of the decree. And hence, it was a enforceable settlement. That was what I was trying to get at. So, everybody with me till now? Anybody getting bored? The ones who are not saying no are probably getting bored. Especially the backbenchers. Backbenchers. Everyone with me? Okay, great. I'm in a backbencher. We'll talk about that in my second section. Okay, so mediation, of course, also finds mention in CPC, in Commercial Codes Act. I think somebody spoke about 12A of Commercial Codes. CPC, you have Section 89. So this matter was referred to mediation under Section 89. Okay? Let me just know when if you guys want to sort of like, if you want to take a break or something, do that. So, types of mediation, court mandated, which is what we just discussed, where the court said, please go and do the mediation, which is Section 89. Then you have legislation specified mediation. For example, Section 442 of the Companies Act says that, it liaison on the process for mediation. Unfortunately, it hasn't taken off the way it should have, but then we don't even have the credit infrastructure for that. Then private mediation is basically we have a dispute, we go to a private mediator or a institution, and we say please mediate the dispute between us, right? That's private mediation. Anybody has an experience of having seen a mediation or anything? Yes. What happened?
It didn't get resolved. In fact, they started fighting in between. They would not want to resolve the dispute. The husband started abusing, the wife started crying. The kids barged in. So it was pretty chaotic. It was
Yeah, also, if somebody else also raised their hand, you raised your hand. Yeah.
White put the classification. So she gave it. Actually, she said, I don't want to fight. I don't want to see this fight anymore. I just want to go back.
Oh.
It got settled.
Good morning, sir. So I was interning at District Legal Services Authority, and there was this mediation session between husband and wife. Both the advocates started fighting, and even the husband and wife started fighting, and the issue didn't resolve at all, and they went on.
Who
Yeah.
So that's unfortunately another part of it. Most of the lawyers are very anti-mediation because they feel that if the matters get resolved, he will go. But that's not the case. I can tell you from personal experience that is not the case. But I'm not going to delve into that because you have still some time to go into the commercial aspects of this thing. Can we have some water bottles here, please, for the kids? No, not for me. You guys are very okay. No. Great. Because I realized that maybe I might need some water or something. Okay. So we can continue. So nobody's seen a actual mediation which does not involve a husband and wife. Anyone? Yeah.
So wherein they were two brothers who were fighting over property, that the case was they made that leasing between the deals. So the dispute was that one of the brothers alleged that the other one has been moving that.
Okay.
So that was the case.
So did anything happen? Did you see it getting resolved or anything?
No, it did not get
Yeah, I know. Okay. See, it's obviously easier said than done. When we do the trainings and all, they're all very, we call it stimulated sessions, these scripted sessions, right? You do positioning and everything in that, and then you figure out that that's not actually how life outside works. So it takes some time to sort of figure it out. Um, but mediation has actually been very fruitful. Like recently, we saw the Hinduja family split their assets, right? Even the Reliance dispute between the Ambani brothers, Mukesh and Anil Ambani, sort of after the courts and everything, it sort of had to be mediated. They tried to mediate it. That's eventually when the dispute was sort of settled. How many of you are aware of the Ambani brothers case? Does anybody know anything about that case? Yes.
So the Ambani with the case went along the line that Mr. Ambani, senior had
Dhirubhai Ambani.
right? And two sons, Anil and Mukesh Ambani. They were property dispute in relation to a division of business itself, whereby the telecom business was given to Mr. Anil Ambani and rest of the major business was given to Mr. Mukesh Ambani. So Mr. Anil Ambani's company did not survive as of now. And they had also, in their mediation plan or the agreement that they also agreed on the fact that Mr. Mukesh Ambani will not enter into the telecom. That's how the terms of the agreement.
Correct. And then Mukesh Ambani entered telecom when he got Jio, and everybody had two numbers, right?
Yes.
Arjun Jio, Papa Jio, Mama Jio, right? Everybody had those numbers back in 2016. Okay, great. So something about was the scope. I think we've already discussed this. That as of today, somewhere around 5 odd crore cases are still pending before various courts, right from the lower courts up to the Supreme Court. There's a lot of scope for mediators, for mediation lawyers, to sort of work on those. I'm sure half of them at least are the cases that can be resolved for mediation. Of course, not all cases can go to ADR. Can someone tell me what cases can't go to ADR? Criminal cases, yes, that's right. Criminal matters, yeah. Industry related issues, okay. You want to say industrial disputes? Yes. Okay, antitrust matters, IPC matters. Yes, anybody else? Okay, can a divorce case go to mediation? What will happen then? Okay, can a divorce case go to arbitration? Tax cases. No, I'm talking about, yes, tax cases can't go to that. I'm talking about, can a divorce case go to arbitrator?
For example, we don't have it in India, but if you have a prenup agreement which talks about arbitration, then it's possible theoretically.
In India, it's not possible. Why it's not possible? Again, prenup, US, come back. Shimla, India. Okay, so yeah. Okay, certain things have been kept out of the scope of arbitration because, certain cases which affect only the parties, such which, judgment in rem, in curiam, which those things which can only affect the parties can go to the arbitration. The one that affects the society at large cannot go to the arbitration. So, what are the types of arbitrations? So, you have domestic, basically two Indian parties doing it here and arbitrating their disputes before an ad hoc or an institutional arbitration. So you'll see there are different color codes. So they are basically the types of differentiations we have made. So domestic, international, commercial. That's one differentiation basis the parties. Okay. So international, of course, one party is Indian, one party is foreign. International commercial is where there's a commercial contract involved. Okay. Then you have ad hoc. What is ad hoc?
It's not institutional. So there's certain institutions like the Delhi International international arbitration centers, the IIAC, MIAC, all these centers have they're the institutions which handle arbitration. When parties decide not to go to these institutions and rather appoint independent arbitrators,
Yes, that's
then
it.
that's another.
Fast track, of course, our act provides for it. So fast track, the word suggests that you fast track it, you do it within a certain period of time. So within 6 months. So you have 6 months to do this arbitration. That's the fast track arbitration, which is in our section 29. If I'm not mistaken. Institutional, like we said, you have institutions in India, abroad, CIAC, LCIA, ICC, MCIA, IAMC, which I'm a part of. Then, DIAC, multiple institutions where the institution sort of takes care of the logistics, appointment of the arbitrators, and the rules that the arbitration will follow. All of this all is actually based on UNCITRAL model. Okay, even our arbitration act is based on UNCITRAL model. So usually you will see there will not be much deviation in the rules that the parties may have. Certain times the parties may decide we don't want evidence. We want only documents, only arbitration. Sometimes they may say, okay, no, there are certain questions where disputes are there and we need to have evidence. So they can choose to have evidence as well in that. By the way, did you guys know that CIAC, the arbitrations that go to CIAC in 2023, almost 65% of them had Indian parties. So that shows the faith that parties have in CIAC. Unfortunately, we've not been able to sort of, build that faith in our institutions here. Maybe at some point of time we'll do it because there are multiple other factors that are required, including, your enforcement mechanism and everything. And that's why we may not have taken off as much as we would have wanted to, but CIAC has. Conciliation, like we said, more like mediation, but more proactive role of a conciliator who can sort of give suggestions, give ideas. But again, parties are free to get up and walk away at any point of time. They can't do that in an arbitration. Conciliation, voluntary, basically two parties go. Compulsory, For example, can anybody give me an example of compulsory conciliation?
Compulsory reference made by the court under Section 89C.
Okay, 1 yes. How many of you seen any infrastructure contract? Anyone seen any of these big contracts? So you will see a lot of these contracts. When you guys work on those contracts, you will see that they'll say that in case a dispute arises between the parties shall endeavor to resolve those disputes through conciliation within 15 days from the receipt of the notice of dispute, failing which the parties can invoke arbitration. So here it's a compulsory thing to do, unless both the parties agree not to do it. But if the party says, I want to go to the arbitration directly, the other party can say that, no, we have to do conciliation first. So it's a compulsory conciliation. You have to tick that box before you move forward. So far, so good. Everybody with me?
Yes.
Understood what we have spoken about?
Yes.
Can I ask questions?
Yes.
Okay, good. What about the ones at the back? Can I ask some questions? You guys have understood what I've said? It's okay, don't worry. You will get this. And I'm here, you can ask me those questions if you want. What are the differences between arbitration, mediation, and conciliation? It's very easy to confuse all those, but there are certain essential differences between them, especially mediation and conciliation. Arbitration, most of us know. So what's first on basis of procedure? So mutually decide with the parties, subject to the Part 3 of the Arbitration Conciliation Act. The institutional rules applied, ancestral rules, mostly ancestral rules. Even our act says ancestral rules. I mean, copy of those. You have in mediation, you have CDR model mediation procedure. Now, hopefully, we'll have our Indian Mediation Act, sort of like give us more rules once those are framed and then notified. Outcome, binding and enforceable. That's very important on this. Binding and enforceable. Mediation, usually non-binding unless the court order directs to the contrary. Parties can enter into a binding agreement. Conciliation, binding and enforceable. Right? Why is this binding and enforceable? I mean, it's similar to mediation. Doesn't have any processes like others. But why do you think it's binding and enforceable? Anyone? Because it has a enforcement process, which is your conciliation process, which is part third of the Arbitration Conciliation Act, which gives it the teeth of enforcement. Correct? Yeah. In fact, if you see the AFCON's judgment of Supreme Court, they said that there is no difference between mediation and conciliation. You can enforce a mediation agreement so long as you call it a conciliation. Right? But it sort of didn't really take off. It sort of really didn't happen the way it should have, because we're still not very mature as a as a market for mediation. It's going to take some time, but hopefully it sort of takes off the way. Role of third party judges, arbitration. The judges act as judges, right? And retired judges also act as judges. Mediator is mostly the guy who sort of engages in discussions with you, facilitates those discussions with you, and helps you to come to a situation which is a win-win situation, which is not adversarial. Right? Now you see the difference? There you have you either win or you lose. Mediation, there's a chance that both of you can end up with something that that will be helpful. Can someone give an example of how that could be? Okay. Mediation, we say that it's a win-win situation. How? Give me an example. How can it be a win-win situation? Yes, I see some hands go up.
So,
we start with, yeah.
Yeah, like for example, you could say that since the litigation system is for primarily adversarial, so there is a win or lose. So there is a yes or no.
Okay.
In a mediation, you can have a gray area. So like there could be a 50-40 or 50-50 or a 70-30, that kind of
Okay.
agreement.
Give me an example.
For example, like we talked about the case, like the case you talked about, the court could have just said that yes, there is an easement thing and so on, but there could still have been more issues which would have led to further litigation maybe.
Right.
But the mediation just settled it in a manner that none of that is needed anymore.
Okay. You have your hand raised.
So for mediation, since it's a voluntary process and it's not binding, and it only comes to an when party comes to an agreement. So no party is going to be in a losing situation and say yes to the final agreement that has been come on upon the mediation.
Okay.
So they could have some kind of benefit. They would try something, even if it is they have to lose out on some matters. They will bring their most factors that are more important to them as compared to the other factors and try to get a benefit in those factors at least.
Sure. So let's take an example. Let's take an example. It's an example of an orange. So there are two people. Okay. What's your name? Gyantika. What's your name? Let's say an orange and Gyantika and Yukti are both fighting for it. Both of them want this orange. And you guys are all mediators. Now, how will you divide that orange between these two? No, you are asking for the orange. Someone did yes.
So it depends on what they want to use the orange for.
Okay.
Do they want the orange for the flavor, or do they want just the?
Just divide it. No? Just divide it between them. Don't give me the reasons. Just divide it between them. How will you divide it?
Again, I asked the parties what they wanted first. Let's say one party wants.
Okay. What do you want the orange for? Okay, what do you want the orange for?
Yeah. Well, then, if both of them want the juice, the orange could easily.
No, but she's saying I don't want the juice. She's saying I want to eat it.
Then we'll have to divide it in half physically. Or
None of them are agreeable to that.
so they don't want half of it.
No, they want the full orange. Both of them are saying that I want the. I don't care about the juice, about the pulp or anything. I want the orange.
So just like we discussed before, we get into the conflict. What is the reason?
That's okay. Now I'm asking you to divide it between them. How will you divide it? You see, your answer is partly right. Let me give you that. I'm not going to tell you which part of it is right because I want everybody to think about it. The answer is partly right, but then how will you do it? Yes, I can see a hand going up there.
So you are talking about the full orange has to be divided as such.
Yes.
So the whole peel part would be given to one party and the whole substance part to the other party.
How is that giving an orange to one?
Yes, sir.
But what is the basis of that?
So because the peel part would be the whole orange covered part. And then
But that's not the orange, no.
Okay.
But that's not the orange. That's just the peel. No, there is a substitute. There is an orange. See, he is accidentally said something which makes sense, but he doesn't know what he's saying. It's just one orange.
It is not about our way or my way. It is like about we should agree on the one particular.
Yes, so that's what I'm telling you. You're listening. See, I'm giving you 2 minutes. If you see, you got the answer between 2-3 people who've spoken. The answer is there. One person has given a bit, another person has given another bit, but it's just for you to sort of think and put together the answer. Yeah, so one loses the whole orange, one will get it. If she wins the orange, she loses the orange. That's it. But now they're in the mediation. Let's think about it. One guy told me, "Sir, मैं खुद ही खा जाऊंगा." Issue ही खत्म हो जाएगा. Yeah, but they don't want half orange. I'm telling you, you guys have answered the question, but not one person has answered the question. 2-3 people have answered the question. But, and I'm given a hint also. Yes. So, no, that will not happen. So she wants to drink the juice. She wants to make a face pack. Right? So what you said was partly right. That I asked them, what do you want to do? Right? She says, I want to eat it. She says, I want to make the face pack. But none of this has come out because they're both fighting for the orange. Right? So what you said accidentally was right, but your logic was wrong that, we'll give him the orange and we'll give her only the peel. Like, okay, this is the orange. That would not be orange, right? That would be just the peel. But what mediation does is, it takes you back to the basics and you ask the question, why? You want an orange. Because when they're fighting in the court, they don't care about, anything. They're just saying, I want the orange, it's mine. He says, I want the orange, it's mine. The judge says, okay, fine. She says, this is the receipt, I bought it, this is my orange. Okay, fine, it's yours. He says, no, the receipt is forged, this is the receipt, I bought it, this is my evidence, this is the fruit seller I bought it from. Okay, orange is yours. So one of them loses, it's an adversarial process, one of them loses, only one of them wins. But if the orange is there, and now you're asking them, what do you need it for? She says, I want to make the juice. I want to make the face pack. Right? And you say, okay, fine. You take the pulp, you make the juice out of it. And you take the peel and make whatever you want to make out of it. That is where mediation comes into play. Right? Now you understand? That is the facilitation. Because you are not telling them, you take the orange, you take the peel. You're asking them. You're making them realize something that's already in them. So this example just to understand how facilitation works. A facilitator will never help you come to a solution. Facilitator will help you think and then you come to a solution. Facilitator doesn't come to a solution. mediator is not going to come to a solution. When we also mediate, we don't say do this or do that. We say look at it from this perspective and see how the court may look at it. Then you think, if I do it, then I may lose. So you would agree to come to the table. The other side, when you're having a private caucus with them, when you're basically having a private chat with them, look, you've taken the money. If he goes to the court, you may win. But imagine the loss of money, the loss of resources, the loss of business. You have to go to the court every day. Court is like 50 kilometers from here. You have to shut your shop. You go in the morning, come back in the night. You pay the lawyer. You lose the business for the whole day, and your reputation goes for. You say, maybe that's right. Even if I win, it's just worth it. That's when you start talking, right? That's where mediation comes in, and conciliation as well. ODR. How many of you know what is ODR? It's online dispute resolution, but what is it? Okay, tell me.
I mean, it's basically mediation, but online we have.
No, it's not. Okay, someone else. ODR does not mean online ADR. Okay, it's easier said than done. I can do a separate. I do a separate session on arbitration, conciliation, which runs like it's a 15-hour thing. And I can tell you, ODR is not online ADR. It's not like you call on WhatsApp somebody and say, now let's do the mediation. That may be a bit of it, maybe. Nothing, may not. Someone else raised their hand. Yes. Okay, that's what you right. Yes.
Modes of transcription or using AI technology in shopping for the huge documents and all. Just using some sort of, as it's written here also, digital technology, which can be used to facilitate normal EDR process, including probably virtual hearings.
Absolutely. And I'm glad that he's the. I thought this when I was wearing tie. There's one more guy wearing a tie, huh? Good, good. Three of us now. Okay. How many of these boys? Oh no, there's one more guy wearing a tie. Just in front of you. You don't remember you're wearing a tie? Sir, you. Yeah, you're wearing a tie. Because he was like completely lost. Like, shit, when did I put this on? Shit, where am I? It's okay, that happens, don't worry. How many of you actually wear ties to college? No one? You guys don't have a mandatory tie to college? Good. You used to have it. Black tie. College, where used to wear those black ties to college.
Yeah, we have it. We have it for their uniform, but they don't.
No, they should not wear it. There is some difference between the lawyers in uniform and the waiters. I'm not kidding you not. I ended up going to a function straight from office, and there was a dude wearing a black. There was a dude who was there wearing a white shirt, black trouser, black shoes. I was wearing white shirt, black trouser, black shoes, and he was going, "Sir, Malai Kofta." I was like, "Okay, I have a bigger issue right now. I need to go back home." Since then, I decided whenever I'm going. Yeah. So my wife really gets annoyed with me because. And this, the boys probably will understand, especially the ones who go into litigation, is that all my shirts are white. So my wife forced me to buy a shirt which is something like this, sky blue color, which I've sort of like never worn, except for when she forced me to wear it. And all my suits are black, charcoal, navy blue. This is the occupational hazard. That's a conflict that I lost long time ago. Yes. See, no matter how big a lawyer you are, when you go home, ma'am, please tell us. Yes. Home Ministry, yes. Home Ministry takes over. Yes, yes, yes. So yeah, I mean, yeah, my wife keeps on saying this thing, and then she keeps on saying, "You don't wear any other color." I said, "I don't feel comfortable in any other color now." And the other day, this happens on Friday. Last Friday, we had an office party. So, and of course, I ended up in the party, with like everybody. So, and the courts were also shut. The courts just started day before. So I was, in a jeans and a t-shirt like everybody else, like the normal human beings. And my driver calls me, sir, वो ना दूसरी गाड़ी के साथ हमारा गाड़ी लग गया है, and they have sort of held me up here and everything. And I go there and I realize, shit, this is the time I should have been in my uniform. I could have easily gotten my guy away, but I was wearing it, so I could now go and throw in their face that I'm a lawyer. So yeah, sort of like it's like when you need it the most, you don't wear the uniform. The Murphy's law, right? So I think that gave a very fantastic debut. Can you just repeat what you said about AD, ODR? I have the right guy. What's your name?
Piyush Pandit, I'm in my fourth year.
Piyush. Piyush, why don't you just say this thing again, what you said about ODR, and I want everybody to sort of listen to this, what he said.
So ODR is a mechanism which assists the normal ADR or dispute resolution process by using digital technology, for example, transcription methods or AI or virtual hearings or any sort of method which facilitates a normal conventional dispute resolution process.
So how many of you got what he said? Okay. Okay. Yes. No, just tell me how many of you understood what he has said. Great. So most of you. For those who did not, they just break it down. What he's essentially saying is that now you have a lot of technology available for you guys, right? Now you have AI, you have chat. How many of you use chat GPT? Please don't use it in your research. Okay? Don't use it in your research because chat GPT will give you case laws that are not there. And this I'm telling you from experience because we've tried this thing. We actually asked one of my colleagues to sort of like, input the data and see what he comes up with. And because we were at some point of time figuring out that, should we use it, should we not use it? It's not helpful for that. Yes, it's a great tool when you're writing your emails, you're writing your cover letters, creating your CVs and all. I think we'll talk more about the CVs in the second session because that's something that I see a lot of problem that you guys face. But don't use it for your research. Okay, that's an advice that I'll give everybody that it's not good. But yeah, so you have ChatGPT, right? You have other AI models. So my wife works in AI. She works on driverless cars, so I know a bit about that from her as well. It's a tool that we can use, right? But brain has to be ours. So do not let that replace the brain. So you have digital method of transmission of documents. One thing that you said, that, online hearing, that's just one part of it. But how you store the documents, how you transmit the documents, how is your evidence led, that's all part of the ODR. So how you effectively use technology to conduct a case, not a hearing, to conduct a case, which includes many steps, one of them which is hearings. Okay, that's ODR. So some of the ODR sessions, some of the ODR things that in fact, there's a friend of mine, how many of you heard of this thing called Sama? Sama, yes. How many of you know them because of Sharpen? One name. Okay, two. So Sama was founded, I'm not going to get in the history of them, I think, so it was founded by two students of NUJS. And then they got this, they won a competition, it was their, so it's sort of like they sort of, it was their eBay moment, what I would call it, because eBay in, I think, late 1990s, they realized a lot of their time and resources were getting wasted to the distribution system. So they came up with an ODR system where you could raise a dispute and get it resolved. Something similar happened with these guys when ICICI Bank came up with this. So now they handle for a lot of people, talking to some guys, and they recently got some funding on Shark Tank as well. So which sort of also shows that, people are willing to put money into that. There are multiple ODS forums, like Sama is there, Vivad, and everybody is there. So what are the career opportunities first in litigation? First and foremost, obviously you can work as a lawyer, right? So you join a seniors chamber, which is like the most traditional way of doing it, which is what I started with. I joined a seniors chamber back home, and I worked with him. So what does it help? You will learn drafting. Let me tell you one more thing. How many of you are in fifth year? Few of you. How does life feel right now? You are in fifth year? Both of you are fifth year. Tell me, how does the life feel right now?
Sir, it feels, with respect to college, it's bittersweet. We're about to be, and yeah, so we have a few days left. With respect to career, it's that in student life you're not that accountable to anybody. So after this, there's this entire phase of accountability because we'll be joining at whatever field we are going in, respectively.
Okay.
So yeah, it's just that.
Okay. Next to you.
So about the college, it's the same,
Okay.
but about the career, it's very confusing and borderline scary.
Okay.
Because judiciary doesn't really happen that frequently.
Okay,
And
correct.
that's about it. It's scary.
Okay. Anyone else? The boys. Any fifth year boys here? No one.
So many boys.
Oh, the fifth year boys. Where are you guys? Okay, tell me.
I probably cannot add anything more to what they have said.
Okay.
It's confusing as for the institutions because yes, we love this place, we also hate other things about it. But starting with this pedestal as a fifth year law student, yes, it's confusing, but at the same time, it's also exciting because we have seen how the law works, we have seen procedure, we have been to the courts, but we've been on the other side.
Okay.
Now we'll get to be the drafters, we'll get to be the pleaders. So confused, but excited at the same time.
Great. All of them are right answers. Your teachers are making notes, huh? Whatever you're saying. So it's like it's like that, you have the right to remain silent. Whatever you say will be and can be used against you in the court. Okay. So yes, I mean that primarily sums it up how most of the fifth years would be feeling right now. I had, of course, similar feelings when I was in my fifth year. Of course, we'll talk about more in detail about that in our second session. So, in terms of what you're going to do when you go out, you realize that there are so many things that you will need to unlearn and relearn and probably freshly learn. And it's not something unique to you. It has happened to me. I'm sure it has happened to your faculty, right? It's happened to all of us, right? Right? It's happened to all of us. So when we are in the fifth year, we are more like Don Corleone. Right? Yeah, she knows what I'm talking about, right? Like ऊपर भगवान नीचे हम बीच में कुछ भी नहीं है. I mean, at least I don't know what you think. So, but it's only when you go out you realize that, and nothing wrong with that, by the way. Not the Don Corleone thing, the next thing that I'm talking about. You realize that you're actually at the bottom of the food chain. Okay? And that's where you need to make a start. College will prepare you for a certain things. One of the things that college prepares you for is what? What's one of the most important common things that college will prepare you for? Can anyone tell me? Yes. The routine. The discipline. Wake up every day despite how you feel. Okay? Don't want to go to the class, you're not feeling well, you don't like the teacher, you don't like your friends, you just had a late night, but you need attendance. You need to attend that lecture. So you wake up in the morning, you go, you don't wash your face, you just end up in the class, especially the hostel areas. Most of my friends used to do that. So hosteliers. I wasn't hosteliers. I was a day boarder, so obviously I always would show up nicely in the college. Plus, of course, I had a image to maintain of Don Carleone. So yeah, I was just joking about that. But we could have some Godfather music playing in the background, right? So you realize that routine is so important, right? And trust me, even today, I'm a partner at a tier one law firm. I have like huge team working for me. I can go to office whenever I want. I can leave from my office whenever I want. I am chauffeur driven. You know, everything is there. Like you probably aspire for at this stage of life, which I did aspire at this life. But still, there are days I just don't want to leave from my home. I have a 5-year-old son, but I sometimes it happens I don't see my son for 2-3 days. We live in the same house because I have to take a morning flight. I have to fly out somewhere. He's sleeping when I leave. When I come back, he's sleeping. Right? So, but those are the sacrifices we all make to be where we want to be. Right? No one in this world has achieved anything without making those sacrifices. No one. And if someone tells you otherwise, they're clearly lying. Or they had generational wealth. But even those, we had an example of Ambani brothers, right? Look at Mukesh Ambani, look at Anil Ambani. Anil Ambani would have landed up in jail if his brother didn't bail him out. And the bugger did it at the last moment to show him. He would have given that money like 10 days in advance. No, he said, okay, fine. Few hours before your arrest, I'm going to bail you out. Just to show, just to make a statement. All these people that you see, they work so much, they work so hard. And trust me, and this of course probably I would have spoken more in the second session, but you know, it's a cliche, but nothing beats hard work. Nothing. I say this thing, and in fact, you know, I keep on saying, and I said, hard work eats attitude for lunch and luck for dinner. Nothing's gonna beat you that, right? And that's where you are in college. That's what the college will prepare you for. And when you go out, you realize you don't know much of the stuff that's happening there. It's not anybody's fault. It's not your college's fault. It's not your fault. It's how the system is designed to work. Right? Should we have a different set of subjects? Maybe. I don't know. Should we have a different approach to our education system? Maybe. Yes. No. Again, I may have some opinions, but you may have a different opinion on that. Your faculty may have a different opinion on that. Right? I was talking to your faculty yesterday over dinner, and there were certain things I was telling him. I said, there are certain things I feel that when the kids are coming out, they need to be prepared for. But they aren't. Again, for nobody's fault. That's why you go to college. So you need that routine. Right? That's why you need to make sure that you get up every morning, get ready, put your best foot forward, and then see what happens. You put your effort. You can't control the result, but you put your effort. You worry too much about the results without putting in the effort. And I say you, I mean like all of us. I'm not pointing at anybody. But those are very important aspects of life. So, when I was in the chamber, I used to be there at 9 in the morning. I would just go to the court directly. You just go to the office, pick up some files, and go to the court. I was in the court till about 4:30. I would go to the chamber. We were in the chamber till about like 10:30, 11 o'clock. Now the fun part is, you know where most of the litigation lawyers chill and get some time to relax? Do you know when is that? Sorry? Yeah, the court. No, not the place. The time. The time is when we are in the court. Because you're waiting for the matters, right? Or your matter is over and your friend's matter is still not over, and you're just like waiting. So you will see a lot of litigation lawyers whose matters may be over, but will still be in the court till 4:30. That's like the only time for us to unwind. I'm like really weird that we unwind there, but that's like the only time we get. Because once we're in the chamber, it's a total, different game altogether. So what happens when you join a chamber? You learn drafting. Your first principles get better. You understand the interpretation of law. You understand the application of law. Okay? And that you need irrespective of whatever practice area you choose, whatever line you choose, judiciary, corporate, law firm, traditional litigation, mediation, because unless your first principles are not in order, you cannot succeed in any of those sections. Sorry, any of those areas. Those are the areas that you really, really need to work upon. Those are the areas you really need to work hard on. Your first principle. Then what happens? So you have niche areas coming up now. I think I was talking to your VC in the morning about tech laws. So now, when I graduated in 2012, about now, it's been 12 years, but the technology has changed so much. There was no deep fake when I was then, right? At best, we had like Facebook and everything. Those are nice, yes, but Instagram, and things that it could lead to, metaverse. There's a case in US that happened. There's a woman who alleged sexual harassment in metaverse. How do you deal with that? And that's why, coming back to my main point, that this is the best time to study law, because I am set in my ways, many ways now. You guys are clean slates. You want to be the best technology lawyer in this country, you can be, because you are the place where that's happening. You have the first mover advantage. I need to unlearn a lot of things for me to relearn a lot of things. You guys have that mind space free. My hard disk is now sort of full of a lot of stuff. I need to delete a lot of stuff. You guys, so much empty space there. Use that. Then, of course, judiciary. Many of you said you want to become judges. So judiciary, you can obviously write an exam and join as what we call as a judicial magistrate, right? Or in some of the Mufassil towns, it's called Munsif. Right? In some states, it's called judicial magistrate first class. Somewhere it's called Munsif. Some it's called metropolitan magistrate, depending upon which state, which part you are in. Okay. Some states need some experience before you can write an exam. Somewhere you can just go as freshers also. It's very state specific. Then the other one is after at least 10 years of service, you can go and write an exam for higher judiciary, where you can basically get appointed as a district judge directly. Okay. Then of course, if you're a great lawyer, or you're a good lawyer, good standing, you get directly elevated to the bench, to the High Court, which is what we'll see a lot of judges in the High Court who are lawyers and now directly elevated as judges. So many ways, and you can obviously contribute a lot, especially in the higher court. You can contribute a lot in setting law. The common law jurisdiction, talking about precedents. Where do those come from? They come from those high court judgments. They come from those Supreme Court judgments. And of course, as a magistrate, as a district judge, you will have a lot of trial work happening, before your eyes. That's what you can become. You can sit for those exams. I wouldn't say they're really tough, but they're really easy as well. So you need to really prepare yourself hard. You get your basic principles right, especially the procedural aspects like the CPC, CRPC, IPC, Evidence Act, and all those things. And those are really, really helpful when you want to sit in your judiciary exam. And then, of course, your substantial laws also, So let's say a place like Himachal, right? There's a lot of focus on land laws, right? Because there are certain guarantees or the protections which are given to them. You'll have a lot of revenue laws which you sort of have to work upon. So different states will have different aspects that you'll have to certainly work upon. Then after, then there's something called as AOR. You guys know what an AOR is? Okay. Advocate on Record in Supreme Court. So you need 5 years of experience, and then out of which 1 year minimum has to be with an AOR. Then that AOR will give you a certificate that yes, you worked with me for 1 year, and then you can go and give that exam. Again, not very difficult, but not very easy as well. So AOR exam is more on application of mind. Your judicial exam is more on the knowledge, right? Your AOR exam is more on application, more on judgments, interpretation of laws, how how laws are interpreted, what you understand from a judgment, how you interpret a certain ratio. It's more on those lines. And then of course you can always have your own chambers, which is what traditionally happens after a few years. You start your own chamber. You can join a law firm, and you can work in a law firm in litigation as well. I'm sure some of you may want think that how is it different? How is it different? In terms of practice, it's not different because it's always the same thing, same code, same briefings. But in terms of how we do it, because as a law firm partner, I have other responsibilities as well. So I sort of have to look into those softer aspects as well. The HR aspect. Like for example, yesterday on my way from Chandigarh to here, I was on a 2 hours call because we were deciding the appraisals of my team. So all of that I probably would not do if I was in a chamber. So yes, like I said, we look into the HR aspects. It's a different because then there's a lot of interaction with other practice areas, corporate projects, tech, capital markets, and everything. So there's a lot of interaction that happens there. But in essence, how the work happens, that remains primarily same. Career opportunities in arbitration, you can obviously, first and foremost, that I do is an arbitration lawyer. Okay, you can end up being an arbitrator as well. If you have that kind of experience and somebody is willing to nominate you, you can become an arbitrator. Okay, so that's another piece of work that you can do. Now you have many institutions where you can work as counsels. You have ICC, you have CAP, you have Nani Palkiwala, you have MCI, you have IMC. In IMC, we have like 5-6 associated deputy counsels who work there. So they are the ones who we would essentially call as case managers, who will run the case, who will do all the logistics of the case, and in the meantime, they get a lot of exposure on how it happens, how it works. Okay. So internationally, of course, you can work with WIPO, you can work with CAC, Hong Kong, ICC. ICC has multiple offices throughout the world. You can work as counsels there, who are the case managers, not the lawyers. And of course, you can always be lawyers. You can always assist. So some of the judges who are the arbitrators now, they have research assistants who assist them in research, who assist them in handling the arbitrations. So to begin with, those are certain opportunities that you can always look at, and then you chart your own course, how you sort of want to go ahead in that. Career opportunities in mediation, of course, you can be a mediator, you can be a mediation lawyer, you can be a consultant, you can be a counsel, you can, like some of you have already worked in district legal service authorities, you can work in local adalats. So those are some of the opportunities when it comes to mediation. ODR, again, you can work as an arbitrator, mediator, counselor, neutral, case managers are the counselors that I spoke about. You have Vivad, Sama, Live, Agami, they all provide opportunities to fresher as well as experienced people. You can get empaneled as an arbitrator, as a mediator in their organization. You can always work as case managers there as well. So those are some of the organizations that hire people at your level as well. In fact, some of these give opportunities to 4th, 5th year students also, and to work as because it's all online, right? Everybody has a laptop and an internet connection. So some students start making money, not much, but sort of to sustain like a pocket money to sort of sustain when they are in like 4th, 5th year, and also get some requisite experience about how it happens. Shifting careers between litigation and ADR, not rocket science. Almost every lawyer that I know does both arbitration and litigation. Okay. So from a lawyer's perspective, it's not difficult. I do litigation as well as arbitration, right? So a litigator can become an arbitrator, but an arbitrator who's just an arbitrator may not become a litigator. Because if he's an engineer, we made him an arbitrator, but he can't come and argue the matter in the court, right? So yes, you can become arbitrators. You can become a mediator also. So none of these essential arbitrator, mediator, none of these essentially require any special degree or any special licensing. You just need to be somebody with good sort of experience in that area. I think in 2020 when they brought an amendment, they got the Schedule 8, but then that was sort of scrapped later because Schedule 8 had given some basic requirements to how to be an arbitrator. But they sort of dropped that. For you to sort of enter into ADR, one of the easiest ways is obviously your district legal service authority, because there are always short on people. they always can use an extra pair of hands to help them out with. So you can always, work there with them. They can, they'll be good experience, and they have like cases in huge numbers. So it's very, very easy to sort of like, get some work there and get some experience. Money wise may not make so much sense, but at least experience wise will make a lot of sense for to sort of like, go and do it. Then you can obviously, have certain courses that you do, certain institutions of arbitration or mediation require you to have certain certifications. That's why a lot of mediators do some certificate. Like I'm also a certified mediator. That's because some of the organizations require you to be a certified mediator before they can refer a case to you. Number one. Number two, it always is always good to sort of learn, and secondly, have a sort of a certification to your name. Just it's more value to your CV, right? So you can do those courses as well. For lawyers, you'll have to write that AIB exam. Yeah, I know. I mean, that's a joke in itself. I mean, I'm sorry to say, but I know I don't know how people fail in that exam. Is it still open book?
Yes.
And still people are failing that exam. I think the people who fail that exam should not. Just not gonna say that. Okay, ADR professional. You can join a litigation firm. You can join an arbitration firm. Basically, a firm that does a lot of arbitration or litigations. You can join a senior counsel. Assist them, and then at your stage, my suggestion would be like do a lot of internships across the spectrum. Don't just get focused on one thing. Do more moods, understand how this works. Mediation and arbitration moods are happening all over the country right now. Negotiation competitions are happening. So take part on those. You at least get a flavor of what it is. It may not be the exact same thing. You still get a basic understanding how things will work, what it is, and how it's gonna, you can familiarize yourself with the processes. Write some papers. That's always a great way to showcase your knowledge. Write some articles on different topics, and there are so many free publications that will happily publish your article. And then when you approach somebody for a job or internship, you can always showcase that I've written X number of articles on this subject, because that shows a lot of depth. So how many of you guys know Richard Feynman? Know the name Richard Feynman? Yeah, so you guys haven't watched Big Bang Theory? At least in that, Richard Feynman was quoted a lot. Richard Feynman once said that the best way to learn something is to teach. Right? And I think that's one of the reasons I teach, is because I love the subject. I teach a lot, the ATR and everything. Because every time I have to take a lecture, I go back the basics. I read it again and again and again. And despite how many times I've done it, because there's always so much that's new that'll come up. Between my last lecture and this lecture, probably some new judgments would have come. So I have to sort of like, really see. Somehow would have, drastically changed what we were thinking about it. Like, I remember this NM Global came between two of my lectures. So in one lecture, I said something, that I had to say something else, right? So similarly, when you write something, it's always, a good way to showcase that, yes, I know the subject, yes, I can interpret the subject, yes, I can apply the subject. Knowledge, interpretation, and application are the three things that you need to showcase to have some sort of expertise or an experience on any of those aspects, and that's something that you guys should really, really look at. And in the end, we only regret the chances that we didn't take. So that brings us to the close of this one. Any questions? I'm happy to answer. Yes.
Sir, I have two very basic questions. The first being that
You can close it.
As a first generation lawyer, what is the distinct set of problems we face in comparison to someone who's been in the industry for long enough? And secondly, when there's pressure in litigation. So there's a certain set of people who will tell you that you should change your workplace every year and expand into every area. Whereas there's a certain set of people who would say that, okay, you work in one place for say 10 years and then you gain experience. So what should we do among both the things, and what is your opinion on this?
Okay. So the first question was on being a first generation lawyer, right? See, I have lawyers in my family. My brother is a lawyer, but I consider myself to be first generation because my father was not a lawyer. So I didn't inherit my father's practice, and I never worked with my brother. Okay, despite his very good practice. So I'm giving my perspective. So there's no right or wrong answer to this. And one of the reasons I left my hometown was because at that point of time I felt that my family's name was casting too big a shadow on me. So I wanted to do something on my own. So I came as a first generation lawyer to Delhi. I think we'll speak obviously more about this in my second session. And I worked there, right? Challenges, if it was my father's practice, I would basically inherit his practice. The challenges are the first kickstart is always okay. That's really difficult. But the good thing is, the silver lining is that after you've crossed that barrier, then it's purely mental. Somebody whose father may have 1,000 cases, but is not a good lawyer, eventually will fizzle out. That's the law of the nature. That's the law of jungle, and it applies here as well. Okay, it is the law of the jungle, and it is how it should be. So initial bid, yes, there are challenges. For you to land a good job as compared to your friend whose father may be senior counsel, or to land a good chamber, it will be difficult. But is it impossible? It's not. And I tell you one thing. Like, when I hire, I do get recommendations. Some judge's son, some politician's daughter, or something like that. And sometimes we can't say no. Okay, because you have to sort of take that person. But I will never have the same respect for that person that I would have for somebody who I hired purely based on his or her merit. And that boy or that girl will definitely get much more work from me. Will definitely rise in that firm much faster. I'm not saying that the other person will not rise. If the other person is also good, your she will also rise. But if it's purely because if the other person otherwise is not smart enough and is got the job only through a contact, there will be a glass ceiling that person will hit extremely soon. But for you, who has gone through merit, who has worked, and who is showing the hunger, who is showing the hard work, okay, there is no glass ceiling for that. That person will grow like anything. So yes, there are disadvantages, but that's not the end of the world. That's what I'm going to tell you, right? You will face those issues initially as a first generation lawyer, but the system will take care of it. So don't let that thing bog you down. I'm not saying that it's not come to your mind, it will come to your mind. You will feel frustrated about it sometime when you see somebody else getting something that you probably should have gotten because of your merit. But in those moments, just keep your head down. Okay? Go back to the basics. Work harder. Because those are the moments that will define your career. If those moments you fail or you start blaming the life, you start blaming the system, you start blaming the luck, then you don't deserve to go forward. Those are the times when you really need to go back and think. I'm again saying it's easier said than done, and right now I can say it because I've been through this system, I've been through that grind. Right? So some of you may feel that it's just a philosophical thing to say, but it's not. It is the harsh reality of life that you will have to face. Second question was that should you jump the job quite often, right? I mean, there are always two sides to it. Personally, I don't think you should do it at least in your first few years because your first principles will not get formed. Okay. You need to get your basics right. But yes, of course, if you're in a very bad chamber where you realize that you're not learning anything, you should leave that. There is a chamber where your learning is there, and I'm not gonna come onto the financials of it because everybody has different priorities in life and different. Some of you may have student loans, some of you may not have student loans. So some of you may have the luxury of switching a job to going to a lower paying job because you like the work there. But some of you may not have that luxury. So you may have to pay the loan and you have to stick to that shitty job for some time, right? That's a luxury, I would say. Hence, my suggestion to the suggestion I give is that give every place some time, learn few things, and when you feel that you have learned, there is no harm in moving on. But if I get a CV where I see that it's a 2019 graduate, which is like 5 years ago, and he or she has changed 3-4 jobs, it's a bit of a red flag. I will not shortlist that CV. I will not give the HR a go ahead on why I'm interviewing. Okay. One bad job, yes. I mean, people change jobs. There is nothing wrong with changing a job, huh? But sometimes you have a horrible boss. Sometimes you are abused mentally, emotionally, right? You change that job, right? But if you've done it like 5 times in 5 years, maybe there's time to introspect also. Right? Yes.
So first of all, pardon me, I did not introduce myself. My name is Sanjay. I'm from fifth year. So in the course of this lecture, you talked about, in the beginning of the lecture, you talked about humility. And towards the end, you also talked about how the system is structured. So litigation and inform, so on and so forth. So I have a basic question. When you entered the practice, what I can see, and perhaps a lot of people would agree with me, that the system tries to change you in a way where you lose your humility, you lose your emotions, and you become a cog in the machine. So when you entered the system, did you face the same challenge, and how did you retain the humility we talked about earlier, and how can a person do that in a corporate environment for that matter, litigation?
Okay. So they are not mutually exclusive. You can be a great lawyer, can be at a very good position, you can still be humble. Okay. The system will change you, and some changes are good. If you don't change, you're just a dead body. Right? Today, I need to upskill myself every day. Otherwise, this is what I tell my team. I said, I want you to make me redundant. Then only I'll do something better. Right? If you don't change, when I say change, I mean if you're not open to learning new things, if you're not open to picking up new stuff, then what are you? Then how do you expect to, keep on going? Survival of the fittest, law of the jungle. Doesn't mean you have to necessarily, become a rude or an arrogant person. Humility will always be there. It's not mutually exclusive. In fact, the more humble you are, the more nimble you are, the better are your chances of accepting a change. Okay, learning something new. So, that you become a cog in the wheel and everything. It's more like a debate on more philosophical lines, right? You do need cogs in the wheels, otherwise your wheel will not work, the machine is not going to work. Somebody has to be that cog. Now, every part of that machine is important. Okay, you may have a supercomputer, but if your switch that's going to turn on your electricity supply is not working, your computer may be worth 50 lakh rupees, your switch is for 50 rupees. If this 50 rupees switch is not working, the 50 lakh computer is not going to work. If my clerk doesn't do his job properly, he doesn't file the file on time, petition on time, I can't get a stay order. Right? So system, when I say system will try to change you, it will not try to change your value system, your morals. Only try to force you to upskill yourself. If you are what you are today, if you're the same person you are next year today, then probably you don't deserve to be in that machine. You need to work on yourself. As a lawyer, you are doomed to reading for the rest of your life. Okay. The least amount of reading that you will do in your life is in the college, by the way. Even today, I read judgments running into hundreds of pages because I need something from there which is going to help me my case. And my junior colleague may not have kind of maturity or understanding to figure it out. So I have to read myself. Right? So that you will have to do. There is no substitute to that. While at the same time maintaining that humility. I'm not saying that you should be humble for the sake of being humble. See, so that's another debate. So some people will try to be humble for the sake of it. That's not humility. That's stupid. Okay, and that's just trying to show off. Okay. What I'm saying is that it should come from within. You have respect for your colleagues, you have respect for the system, for the organization, for your teachers, for your elders, for your juniors, for the chair, right? That's the humility that's important. I hope that answers the question. Anyone else? We can take a couple of more questions. Yeah. Ladies first.
Yes, sir. Sir, my question is that what difference does it make to one's learning curve if one joins a chamber right after college, or he or she joins a disputes team in a firm? So that's my first question. And so my second question is that if I say that if I join a chamber today right after college, and I want to switch now after 2 years, I want to switch to a disputes team in the corporate sector. So, what are my chances of being hired over a person who's coming from another firm?
Okay. So I think the first question was joining the chamber, right? Yeah. So essentially the work will be the same. The firms tend to be more structured. In the chamber, you'll have one senior and then a bunch of juniors, right? In my team, you'll have a partner, a principal associate, a senior associate, and an associate who will have different levels, A0, A1, A2, A3, whatever, SA1, SA2, and all those things. So those are the sort of essential differences. It's more structured in a law firm. Of course, it's more paying than a regular chamber as well, but I'm not going to get into that aspect right now. It's more structured. But when you're out of that building, on the road in the court, you're exactly the same. You're doing the same thing. You're doing the same stuff. You're doing the same work. Some of the chambers, firms, you will probably not get so many chances to appear before the court because some firms traditionally tend to rely more on the counsels, on senior counsels and everything. And in some firms, you will, like in our firm, everybody appears. Right from an A0 to the partner, we make sure that everybody appears. And of course, we brief seniors also when required, like if the client asks or if the matter is like that, if the other side is, or it's a matter of strategy. Can we argue? Yes, we can argue. Sometimes you need to take a senior counsel, right? So that's your answer to your first question. Second question is that will somebody from a chamber be at a disadvantageous position vis-a-vis somebody in the law firm? I don't think so. Okay, because it will all boil down to what kind of work you've done. Because so many people that we have hired are the ones who have come from chambers. The only time you may be at a disadvantage would be if there's a mismatch between the kind of work you've done vis-a-vis what we are looking for. So let's say let's say I am looking for somebody in my team to do infra arbitrations. Now you have 2 years of experience in a civil chamber where you haven't done any of the arbitration. Then there's a guy in another firm or any other chamber also who's done this kind of work for a couple of years. That person has an advantage over you. You may be 1 year senior to that person, but that person has done more work. So it's pure economics, there is pure commerce that that person I'll have to spend lesser time in training that person. But if there is something to the requirements for a 2-year associate who's done civil work, then you will have an advantage over that person. So I don't think there's a disadvantage like that. So it will all depend on your work, like and the relevant vacancy. Now, if you are a guy who has done more regulatory work, I don't do regulatory, but you want to come and join my team. So for me, you're basically an A0. You may have certain understanding of how it works, but my work, you have no understanding at all. I have to train you from scratch. So for me, you're an A0. But if I get a guy who is more, in sync with what I'm doing, I'll have an advantage. So like I said, it'll depend upon where you're coming from, what you've done. I think somebody, you had a question. Yeah.
Good afternoon, sir. I am Parakram Sekri from 4th year. And my question is that I know that there is no one-size-fits-all solution, but if you were to suggest a roadmap to make a successful career in a corporate disputes team in today's time, so like what would you do? Like if you were a college student in my place in 4th year, so what would you be doing to make a successful career? Like, can you suggest?
I'll join my second session. I'll answer this question in the second session. Yes, I think there's one. Yes.
Mr. Kumari, as a law student, we come across a lot of people saying that, okay, this firm, people of this firm are very toxic, or probably this office, Mumbai office is very nice, but the Delhi people of the same firm are very toxic. I mean, we come across this word a lot.
We all read Legally India's posts. It's
Not
okay.
necessarily, but people who come up. I mean, personally, at one of my internships, also I saw an associate who was not just rude and hostile to his colleagues or juniors, but also the interns. So, as a fresher who goes into the profession, how do you suggest we deal with it, and how true do you think that is?
Okay, that's a bit of a controversial question, but I'll try to answer that. If your question is that once you join a law firm or a chamber, will there be people who you will not like and who will not like you? The answer is yes. Okay. It all depends on each one of us to, work on it. I have been fortunate enough to work in teams which were like always good, and I have made sure that ever since I became a senior associate, I've made sure that my team's environment and atmosphere is always very nice to be in. Okay. In our office, we lay very specific emphasis on our culture. And I'm of course not going to speak for the other firms or defend or offend any other firm, choose any other firm or anything. But think of it from a different perspective. Do you feel so entitled in life that wherever you go, you should be mollycoddled? I mean, how naive of you then? God. I'm not saying you're wrong. Think about it. What I'm saying is that when out there, you have to work. It's a different thing when you're in college. Even if a teacher is strict, they'll still be nice. Because for them, you're always going to be their kid. One of my teachers, and I'll give you one anecdote. Actually, two short stories. We have 5 more minutes, right? Yeah. No, so Akshara is looking at me, so I thought maybe our time's up. So there's this one teacher in my class 12. Probably Hitler would be scared of that guy. He was such a weird person. We would be like really scared of him. No, Hitler would be scared of the other lady that I'm talking about. This guy was like really, really, I mean, beep, beep, beep. Okay. And we were like always scared. This was 2006 when I was studying with him. Cut to 2013, I go to my senior's table in our chamber, and I see him sitting there. I immediately greeted him. And he got up and he hugged me. He said, you were studying, in my class in 2006. He said, how do you remember? Oh, I remember you. I said, okay, great. And then my senior told him that, oh, his father is a very bright guy, good things he said about me. You guys said earlier today. And you know what he said? And this is something I want all of you all to internalize. He said, there's only 2 sets of people in this world who will always be happy that you've done well. One is your parents and one is your teachers. And he said, I'm so happy that you're doing so well. I was like, really, I was surprised. Firstly, that person is able to emotions. Because we always thought he was a ice cold stone. He never smiled. He was like Gautam Gambhir raised to power 10. The guy never smiled. And once I went back to my school, I was invited as guest of honor for something I had gone there. And there was one teacher. We used to be like, I'm sorry, ma'am, for this language, but we used to be like shit scared of her. Okay. She was like something else. Like, I think the principal would be scared of her. He was so dangerous. Like, nobody would say anything to her, and we were like so scared of her. She used to teach me, by the way, when I was in class third or fourth. But she was like one of those old timer teachers who was I probably was probably still in that school, and like you could be like Don Carleone, you would still be scared of her. So I'm just giving you the context of how she was. So I go to school, and I'm sitting there, like this. I'm enjoying my moment as a chief guest. She walks in, and I immediately sit like this. This was a reaction, it was like completely involuntary reaction. Because, and then after we got done, I went, I said meeting. So she hugged me and she started crying. Crying, and I got emotional. And she said something I remember to this day. I'm so thankful to God. He kept me alive to see the day that you come back to the school as a chief guest. And I was like, so, like, I got so emotional. So, dude, that's what I'm trying to tell you. The reason I'm saying this is because this I'm not going to expect when I go to the office. This kind of love and affection stops once you're out your student life. So, is there toxicity? Yes, there is. Can you avoid it? No, you can't. So, if you are a guy who goes and works there, now, if you come from a family that has enough money, you say, I don't need to take this nonsense. I'll quit, I'll do something else. I'll become a blogger, or whatever. But if you ever think of it, but if you have a responsibility, right? You have to pay off your loan. Your father probably is, not just you, somebody's father is not there, or who has some other responsibility, or there's an ailment in the family, there's a bereavement in the family. What will you think at that point of time? Toxicity, making sure that there's food at the table. It's always like that. There is no one size fits all approach to this. Yes, there are people who are absolutely, horrible to even be with. And you'll have to encounter them. But you can't expect everybody to like you, like the way you don't like everybody. So if you feel that, this person is toxic, maybe this person thinks you are toxic. Right? So once you're out of the college, leave this entitlement here on you. Go there with a clean mind. And still, if you feel there's something wrong, always make sure that you respect the other person and at the same time your own self. Each and every firm, the ones that are bigger ones that I'm talking about, has a properly established system of escalations. So if my senior associate is bullying my associate, okay, I'll get to know. Or that if that associate doesn't come up to me and talk to me, then there is something wrong with me, not with that associate. It means I have not created that environment in my team where she or he feels secure to come and speak about another colleague, right? So that's how the system works. Go there, work hard, do your best, and don't get into these, we call this gossiping debates that keep on happening. Most of it is basically people just venting out their own nonsense. Okay, nobody likes everybody, and everybody doesn't like nobody. So don't get into all those things. You have a long way to go. You're just what 22, 21, 23. I don't know, but I'm guessing if you're graduating next year, so this is what your age is going to be. A long way to go. Just keep working hard, stay humble, stay nimble, and don't get detracted by these kind of discussions. I think the yellow T-shirt, you had a question.
So my question is like how to determine the place of how to determine the place of starting a litigation practice.
Multiple things. For example, where are you from?
Shimla.
You can start from Shimla. If you feel Shimla is the place you want to be, and secondly, if you feel that see, one of the advantage you will have is you won't have to spend money on living because that your parents will take care of, right? You are familiar with the city. You will probably be able to open your own chamber sooner than later because a lot of your friends, their parents, your family, they may refer cases to you. So you're a local guy who has an advantage, right? That's one way of looking at it. Second way is that you want to go to a bigger place, you want to really hustle for first few years, struggle, and you think okay, I want to go into Delhi and then work in Delhi and then work all the way up to being an AOR or work in the Supreme Court. You take that call and you go there. It's a very individual call. It will all depend on your family circumstances, your own aptitude. Like, if you're somebody who cannot stand hot weather, what will you do in Delhi? Or if you're somebody who's just a only child, you will not want to leave your parents and go, right? So like I said, there is no one answer for all. I can obviously give a very curated answer to a person based his interest, based her interest and everything. But the general principles would be A, you'll have to obviously think of finances, litigation especially. Two, you'll always have to think about how you're going to manage your family. Three, you have to see you have an advantage at a certain place. One of my friends, he's from a very remote village in Jammu division. He practices there. He said, I love it here. He said, I am making as much money as other guys are making in Jammu, but I don't have that many expenses. Right? And he said, I'm happy here. My family is here. My grandmother is here. And, I'm able to spend time. I go home early, and he's one of the top guys there. Because it was easier, like a smaller place. For you to make your name in Delhi, it's much difficult than for you to make your name, say, in a place like Shimla. It's a smaller place, smaller number of people competing for the same space, right? So think about it, take your own factors into mind, and then decide what works best for you. Because what may work for me may not work for you, right? I can only guide you on the general principles. You'll have to adapt them to your own situation and come up with a solution for yourself. I hope that answers your question. Okay, I think with that we come to a close. Thank you so much. Thanks for being so patient. I hope I did not bore you guys. I'll see you in my second session post lunch. Okay? Thank you so much.
Thank you, sir. And regarding the time, I wish we had more time limits. And now that we've seen how the system works, we're more excited to see how the system works for you. And that will be what our next
I'm
section
quite
is
scared of that. My second session, I wanted to avoid that.
No, we've seen the kind of person that you are. You're quite interesting. But what snippets we could see, and I'm sure I'm echoing the sentiment here, is that you've met more interesting people. So I hope we get to see more of that in the second session. And I request everyone to be seated in the moot court hall at 2 p.m. sharp to get to know more about the journey that Sir has faced from being one of us to being here. And I hope we all can learn something from that. And everybody please remain seated for a while. We will take attendance and then we can proceed on to lunch.